Hit the mic. Can we get the?
You're on.
All right. Good afternoon and welcome to the new live television series offered by the law offices of Melissa Day, entitled "On the Bench." And as you can see, we're literally sitting on a bench, and it's quite possibly the hardest bench I've ever sat on. Today is our pilot or first episode, and we're going to be talking about asphalt. I know many of you may have been waiting to hear about diaper cakes. That is going to be episode 2. Unfortunately, my colleague Henry Tilson had an emergency and couldn't be with us today. So
actually, it's at a date to be determined in the future.
Right, at a date to be determined in the future. So Mr. Tilson will be with us during the next episode. But for today, it's myself, James Cousins, an associate with the law offices of Melissa Day, and our fearless leader, managing attorney, Melissa Day. We want you to bear with us if there are any technical issues. Again, this is our pilot episode, our first time. We are working.
I know. Look at the camera.
Oh, look at the camera. I'm supposed to look at the camera. I'm used to looking at a judge.
He's enamored with the image of himself on the television screen right now.
I am. And we should probably note for these purposes that this is unscripted. So we'll try and keep it PG. I don't have a prompter. But before we get into it, I need to give you a lawyerly disclaimer, as I have been wont to do in the past, and the rest of us have as well. This is attorney advertising. So past results, as we may discuss today, do not guarantee future outcomes as awesome as the past results may have been. And to begin, we're going to start talking about our case. And I will ask our production assistant to get us our screen. There we go. Excellent. So today we're talking about a very unique case, a case that our office has handled for many years, at least 2.5 years now, I think going on 3. And this case recently became a matter of public record thanks to the Appellate Division, 3rd Department, proving that we were right and the board was wrong. I'm going to be a little bit flippant and arrogant about that because
we are recording this.
We are recording this because... You know what? We've been saying it from the beginning. So let me tell you a little bit about the background of this case. In the summer of 2014, a young man took a part-time seasonal position with a highway department doing outdoor labor. And at that time, he was doing 2 different jobs primarily. He was brush clearing, which you can imagine involved cutting down branches, picking up twigs, leaves, etc., chipping them. The other job that he was performing at that point was asphalt road patching. And the asphalt road patching involved collecting asphalt from a dump truck in a wheelbarrow and moving it around. Yeah, I will look at the camera today. And moving it around and putting it into holes so that other members, like apparently full-time or full employees, could fill these potholes. The claimant worked for the employer for approximately 2 months before experiencing what he described as pain in his neck and his shoulder. And he went off of work without notice. And when he returned to work, he produced an off-work slip saying that he was being treated for a condition by a chiropractor. After he was released back to work by this chiropractor, he returned a note to the employer explaining why he was out of work. It turns out that the claimant never bothered to explain that maybe this had been caused by work, and it was never really explained what was wrong with him. He went back to work and continued working for the rest of his summer work, and then returned back to school. He went back to school and finished his semester, came back home and was playing some recreational basketball. That's not something that I do.
So just to be clear, when he lost time during that summer, the employer had no idea that this was related to or potentially related to his employment.
Absolutely.
Correct?
Zero idea. And interestingly enough, when the case came to trial, the claimant was, I think, surprisingly honest about that fact. He said he didn't recall any particular conversation with the employer, but he was certain that he did not inform them that it was a work-related injury. And the employer witness that was produced testified similarly that a note was given to him. He asked him if he was okay. The claimant said yeah, and they couldn't really remember the specifics, but the employer was also certain that there was no discussion of work-related injury. because we developed testimony about what would have happened had it even been suggested in a third half-sided manner that it was work-related. There would have been an entire long process that would have involved paperwork and documentation.
Forms filled out in triplicate.
Absolutely. And they would have probably sent him to a physician to get him treated, which is very interesting too, because as we develop the fact pattern, what ends up happening is in December of 2014, so we're looking at 5 months after the accident, the claimant's playing a game of recreational basketball. For those of you who know me, that's something that I would probably never do. But he played a game of rec basketball, and all of a sudden his shoulder started to hurt. And he then goes to his primary care physician and is ultimately referred to a treating physician, well-known orthopedist, actually one of the more reasonable ones in our area, who takes a history from the claimant that, among other things, he'd been a high school volleyball player, so he's doing a lot of, this and spiking and jumping and falling. And that after he was a high school volleyball player, he then apparently, while working for this employer, alleged that his shoulder had been tweaked while he was lifting a wheelbarrow load full of asphalt. And he gave a specific date. He even gave the time that it happened when he first noticed that it occurred. So the doctor says, well, okay, this is interesting. What else? And the claimant says, well, my shoulder was feeling better, but then I was playing rec basketball with my friends, and all of a sudden, don't you know, it started hurting again. So we have a really interesting fact pattern here where a claimant alleges that he injured himself at work but never told anyone. He sought a treatment for about a week. He was off work for about a week. And that chiropractor, by the way, released him to full duty on statements from the claimant recorded in the narrative saying that he had no more symptoms and that he was good to go. So the claimant comes back and the surgeon now says, well, I can't be sure that this is exactly caused by work, but it makes perfect sense. So we think we should file a workers' compensation claim. And in January of 2016, so 6 months later.
I believe it was 15, wasn't it?
15. The claimant, it was so long ago, and I've been handling this case for so long, I want to bring it into the future. It makes me feel younger. In 15, the claimant files a C3 and notifies the board that he had a work-related injury to his shoulder, and the board in turn notifies the third-party administrator, and then the employer finds out in February of 2015. So the employer knew nothing about this. Now, a notice was given with the filing of the C3, but the employer came in and testified, listen, my first notice was when this got processed and the delay from the board and getting it to the TPA and then turning it back into the insured or the employer to let them know that there was a claim against them.
And the claimant didn't give formal notice until approximately 8 months after the accident?
Yes.
That he remembered and he identified with specificity.
Right. And in fact, interestingly enough, I when we were trying this case, I know it's not the standard of law, but I wanted to get it across that the claimant had actually never, ever, from the time that he was injured to even the time we were sitting in court, done anything other than file the C3 to tell his employer that he'd been hurt at work.
Which was definitely late under the statute.
Definitely late under the statute. So the case goes to trial, and we take testimony, some of which I've already told you about. The claimant concedes that he had this pain, and he sought treatment from a chiropractor. He concedes that his pain had resolved, although his statements are somewhat equivocal. He was not the best witness, I would say. And ultimately, he says he went back to school. He attributed the subsidence in his symptoms to the fact that he was now no longer active and he was at school, although he fails to explain how it was that he worked for the balance of the month of August doing the same heavy labor.
Pretty physical labor,
symptom-free. And that he was okay until he was playing this game of basketball and sought treatment. One of the important set of facts that we were able to get also was we were able to obtain all of the intake sheets from the physicians that he had seen beginning in December. So we got the intake sheet from the chiropractor from July, and we got the intake sheet from the orthopedic surgeon in December and the primary care physician that had seen them before then. And in all of these forms, the claimant initially claims that, either he had no idea what caused it, or then variously, yes, I had an accident at work on thus and such a date at thus and such a time, and I've had problems ever since, which again is sort of belied by the record. So the case goes to trial, and that's what the claimant testifies to. He also concedes, again, he never gave notice to his employer. He never discussed with them the fact that this time off was work-related. The employer confirms that there's no notice given. And at the conclusion of that trial, we moved to dismiss the case. We told the judge, listen, we have established that there's no notice here. And in response to that, claimant's counsel says, well, we might be articulating a theory that this could be in the way of an occupational disease, at which time my jaw dropped. And I said, are you kidding me? There is nothing in this record that remotely supports the theory that this is an occupational disease. Your client just testified to an accident.
So at the conclusion of claimant's testimony, you asked the court to disallow based on the fact that no notice was given and the evidence clearly indicated that this was an accident.
Absolutely. Why should our client pay for medical depositions, court reporters, and legal fees associated with medicals when it's not a medical issue at all? It's a question of did the claimant describe an accident? And the findings, interestingly enough, when you look at the case law, whether something is described as an accident or occupational disease is within the province of the court, and there was no need to develop medical testimony to come to that conclusion. The claimant had just described an accident, and the law says that an accident is what is perceived as such in the common sense view of the ordinary person. And so I was sort of surprised and happy that maybe for once common sense would be what I'd be arguing before the Workers' Compensation Board.
And James, this seems as though in order to make that kind of what I would call a very aggressive motion at the end of claimant's testimony, because you really have to embrace the idea that this was an accident that happened at work, correct?
Yeah, absolutely. And in fact, we're going to move on to our next slide.
That was magical.
No, I think we want to talk about exactly how we went about it. But I think first we want to talk a little bit about why it was that we were so vigorously defending what would appear to be otherwise a very, not necessarily a federal-sized case, but certainly a case that would give any employer pause and certainly would raise all kinds of red flags. And it really revolves around both exposure and, again, I think the fact that there was no notice. But first, we have a claimant who's a part-time seasonal employee, which unless you are very aggressive about the case law, judges tend to apply 200 multiples to those things and give claimants average weekly wages that would indicate that, boy, they were really raking in the dough when really they were only making $100 a week working 5 hours. So part-time seasonal employment is always a problem because you either want to limit the average weekly wage dramatically or limit the scope of periods of lost time that could be claimed on a case. And that's the Till case, the teacher case that really has become precedential case law that we all cite when we talk about part-time seasonal or people that have recurrent repetitive layoffs.
This is the reverse of a teacher situation, right? I mean, this was a college student who was just working during the summer?
Absolutely. And in fact, we asked him several questions during testimony, and he confirmed that he had no intention of going back to this employment ever. He wasn't even intending to go back the next summer. He had just said, I did it for this summer. I had no intent. It was just something to do to earn some money. And I was never intending to go back. It was just something that I was able to get. And we were setting that up because we were, of course, concerned that when you defend a file, you want to make sure that if push does come to shove, you want to have facts favorable to you. And this claimant was, to quote or to paraphrase Dr. Bagnall, of somewhat limited insight. And so he seemed to be telling the truth and giving honest answers, even though he may have been well prepared by his counsel. The other problem we have is we have a 20-year-old employee, so we have minor's wage. Not only do we have minor's wage, as Melissa pointed out, we have a minor who's going to college and took a job that clearly has no bearing on what he's going into college for, because he's not going to college to be a part-time seasonal laborer doing highway work. He was going to college for some other purpose.
He didn't have aspirations of filling potholes for the rest of his life with asphalt?
No, but I think we could probably use more of those folks in the state.
Definitely in this town. Yes,
definitely in this town. You could make a good living just filling potholes, even if it was flat fee. And, he testified that, he was going back to school, and by the time the case did go to trial, he had, in fact, returned to school for 2 full semesters. So he was continuing his education. So what we have in that case is one of the exceptional or unique circumstances of minor's wage, which was brought about from some really old case law where newspaper boys in Buffalo who were going to college to become doctors were getting injured while doing their newspaper work. And the Workers' Compensation Board said, wow, it's really unfair to give you a minor's wage adjustment based on what a 25-year-old newspaper boy would be when you're going to school to be a doctor. So we have an exceptional case here. The claimant may be able to prove that he was far enough along in his education and his goals towards a career that he could articulate a case for, say, making this employer all of a sudden have to pay permanency exposure on a physical therapist or an engineer, or clearly some wage that they were not insuring themselves or were obviously risk assessing themselves for when they hired an $8.50 an hour 20-year-old summer laborer.
So you have a situation where you have an employer whose total exposure for wages for an individual for, say, a summer might approach as high as $2,000, who's facing liability for permanency for that same individual well in excess of 10 times that amount.
Oh, way more than that. I mean, the numbers, I think the multiples, you're right, the multiples would just be a big number. I mean, the average weekly wage was low, but then when you think about, we've got a shoulder, 312 weeks. If he gets a 30% schedule of a shoulder, we're looking at 30 weeks of benefits at a total disability rate that could be, he could max out the rate if he proves something.
Right.
Now,
so you can see how that would be potentially unpalatable to an employer.
Absolutely. Now, medical, this is where we sort of jump back a little bit to the background. Obviously, we now have a 20-year-old claimant who's claiming a shoulder injury, and 20 years, life expectancy is what, like 70? He's an injured worker. I always jokingly say that injured workers tend to live forever. So, he could live till he's 75, and you could be paying for a shoulder treatment for this claimant for the rest of his life. And God knows if over the course of that life...
Unless you hired... Oh, no, wait.
No, you can't say that.
We don't want to suggest that we could get future...
So unless... So, I mean, and the thing is, too, is that the longer a claim opens, I think the more time there is for nefarious shenanigans. So that's, that one shoulder injury
Never
turns
happens.
into a consequential opposite shoulder injury, turns into I was strained my neck while doing PT.
My doctor yelled at me for not doing the PT that I was supposed to do, and I ended up with a hearing loss.
Yeah, or, I'm 20 years old and my life's ruined, so I have depression. You name it, it's possible.
ANCR body.
ANCR body, it's possible. So the medical was certainly an issue here, and we did take the testimony of the treating doctor, and this is where we're going to jump back a touch to the background real quick, and tell you that the treating doctor was, as we argued and as the later courts decided with us, very equivocal about the cause of this injury, given all of the things that happened. And the reason he was is that we found out that we had a 20-year-old worker who didn't just sort of strain his arm, he sustained a full-thickness rotator cuff tear and a partial thickness rotator cuff tear. And the doctor repeatedly said and offered it up on his own to say, I do not see this very often. This is incredibly rare. An otherwise healthy 20-year-old male simply does not sustain significant rotator cuff tears. So one of the questions we
absent some sort of traumatic kind of incident, right?
That was almost exactly the question I asked, and he had probably, yeah. He goes, well, I don't know the nature, I don't know the quality of the collagen or the tissues, but yeah, probably true.
So you had a causal relationship.
We did have some causal relationship argument there, and we also argued with the doctor about temporal causation. Physicians love to use temporal causation until it keeps them from billing workers' comp. And in this case, what was interesting was that temporal causation favored the basketball incident, because the claimant's symptoms, if you looked at the timeline, and this is how we took the doctor through it, the claimant had symptoms in July that resolved a week later with chiropractic care. The claimant was then, according to the medical records, symptom-free until December. He then plays basketball and develops symptoms again. And when he develops the symptoms after basketball, they do not remit. They are constant and ultimately lead to conservative care, surgery, post-operative PT, and to some extent complaints of consequential injuries that ultimately had to be dealt with.
So you had a defense based on causal relationship, but it doesn't sound like necessarily that was the most compelling argument for you on this case.
That's right. And we'll push the button here. Look at that. It's like, it's the wonders of technology.
Magic of television.
I know. I look really more authoritative and powerful being able to push that button like that. In any event, so what we want to talk about now a little bit is trial strategy. I jokingly refer to it as strategery because sometimes you're not entirely sure what you're going to do until you're doing it, because these claims just sometimes come out of left field. So we decided in this case early on that there was a good defense on causation and that we were going to pursue it to an extent. but that ultimately one of our concerns was that the claimant reported an accident that simply wasn't witnessed and couldn't be verified. And ultimately, he did produce some medical evidence of treatment that was contemporaneous.
Tough to fight.
Right. Now, the confusion about what injury he sustained immediately at that time, because the chiropractor is talking about the neck. I cracked his neck and his pain went away. That's a medical question which we did push the doctors on. Could it have been a shoulder? Could he possibly have had a shoulder injury that resolved with chiropractic care? The orthopedist demurred on that because he's not a chiropractor. I think that was kind of that was a punt because it was a cop-out. But we have an accident that we really can't dispute occurred. And in the absence of any dispute that this accident occurred, and of course, the claimant, we could argue that the claimant's not credible, but ultimately, I need some sort of evidence beyond just saying this claimant's a liar to convince a judge usually to disbelieve the claimant's testimony entirely about the happening of an accident. So we elected to simply go with the fact that something happened, and we took it from there.
In my review of the filings that your brief to the appellate division and the appellate division's decision, the fact that you embraced the occurrence of an accident ultimately, in most cases, is going to end up with leading to liability. But the fact that you, with the client, embraced this theory of accident really turned out to be your strength in this case.
Yeah, I think it threw off our opponents a little bit because we were so focused on getting the claimant to testify about how he hurt himself, and the claimant was very happy and obliging to tell us how he hurt himself. And he was very happy to confirm all of the histories that he provided to the doctors. And in fact, he was even happy to confirm that on his C3 he reported an accident at a date and time. And I have a suspicion that the C3 being typed was probably filled out by his counsel, and then it was
or a girlfriend.
Could have been a girlfriend, yeah, and was ultimately reviewed by him. Actually, oddly enough, at one point when we were showing him one of the intake forms, I asked him to identify the handwriting. He goes, "That's my mom's handwriting."
I was just thinking about the fact that his mother accompanied him to one of the hearings, and when I said girlfriend, I immediately thought, actually, it was probably his mom.
It could have been his mom, yeah. And in fact, I asked him why, and he goes, "Well, it's legible. That's how I know it's my mom's handwriting." So his mom filled out his forms for him, and he signed them. And his mom was she was present during all of these proceedings. And I think to a certain extent, as you all may have encountered in your claims handling past, when spouses, mothers, and relatives get involved in workers' compensation claims, you usually have a problem because the ordinary sort of disgust that a claimant will sometimes experience by saying, "Oh, they're really pushing back, it's not worth it," will sometimes be overcome by a spouse or a sibling or a parent saying, "Those people, did you wrong." And of course, there's lots of fallacies among the general public about what workers' compensation really is. So people oftentimes operate under false assumptions about what they're going to get out of their case.
Or they themselves had a comp claim and perhaps were successful in getting it established and believe that whatever occurred in connection with their claim should help their loved one be able to get their claim established.
Yeah, I got $20,000, so you should too.
Everybody's arm is worth $20,000.
Oh yeah.
Except yours.
Oh, I was just gonna say I hurt myself walking in here.
I fired you this morning.
Oh, does that mean I can leave now?
No.
So, our strategy was to begin to narrowly tailor this case, particularly once we started to get good testimony at trial. And it was so narrow at the point that we got to the end of the testimony that we moved for dismissal on grounds of Section 18, because we argued that there was clear evidence of an accident. There was an affirmative statement from the claimant that notice was never provided. The off-work slip was insufficient notice of a work-related accident under law, and that the employer was prejudiced here because the employer particularly came forward with very affirmative statements about what processes and investigation it would have undertaken. And we found out, too, that, for example, the day that he alleged that he was injured, there were 5 other employees, all seasonal employees, who were working alongside him. We weren't able to produce any of those witnesses. We were barely able to get the roster, like the schedule, because it was so old. It had to be recovered with, I think, great effort.
So having a good procedure in place for an employer to document exactly the steps that they would take once an injury occurs is very important then in being able to prove prejudice, isn't it?
Yeah, exactly. And I think just to jump back quickly, notice must be provided in writing within 30 days of an accident. Notice can be provided by other means. An employer can obtain constructive notice, and sometimes constructive notice can be construed as oral notice. So a claimant telling a supervisor, even if it's not the person who ordinarily would receive accident reports, as long as a supervisor or somebody in a position of authority has been told, that could be constructive notice of the claim. Late notice can also be excused in the absence of prejudice to the employer. So you could have a claimant produce very late notice to an employer. But if the claimant can prove that there's absolutely no prejudice to the employer for the late notice,
and it's the claimant's burden.
It is the claimant's burden. They have to prove no prejudice. It's actually really, it should be a more favorable standard than case law would have you suspect. Even though case law says it, there's oftentimes an accidental or malicious, intentional switching of the burden by saying, well, we don't see any evidence of prejudice in this record, and therefore we're going to allow late notice and we're going to find that Section 18 doesn't bar the claim. The actual analysis should read, the claimant bears the burden of producing evidence of prejudice, and we see that they haven't bothered to do that here. And although the record contains no evidence of prejudice, it's not our place to supplement the claimant's burden. They won't do that very often, but they should. Now, what happens in this case is that not only do we have all of these procedures in place that would have permitted the employer to have, I think, a better defense of the claim, but they would have also potentially have prevented this injury from worsening, because there's clear evidence from the claimant's physician during his testimony. Although he refused to say that the basketball event was the temporal cause, in fact, which I was pushing him to say, he said he thought it was more likely an exacerbation. But it was the exacerbation that led to the disability and ultimately to the filing of the claim and then ultimately to all the treatment that subsequently followed. So I believe that there is substantial evidence of that. But in any event, the case is not dismissed at the hearing. The judge refuses to entertain the ruling. He wants to hear a development of the record. And I'll tell you that as part of the strategery here, and the fact that we weren't entirely sure what an IME might say given these complex facts, we spent a lot of time discussing with the client whether or not we should obtain an IME at all. And
what did you decide ultimately?
We ultimately decided not to get one. We had some very good IMEs on the panel to select from, but it wasn't until on the eve of trial that we were able to obtain the notes from the chiropractor. That was the first problem, and which of course is one of the ways that the expedited hearing process oftentimes puts employers behind an unreasonable 8-ball. And also, we were concerned that if we weren't incredibly careful with our cover letter, potentially incredibly careful to the point where the cover letter could become a problem itself, we're going to find a doctor who says, yeah, I guess it's rational to state X. And it's one of the problems with obtaining IMEs in some cases. When you're directed to produce an IME before the claimant testifies, you're relying on the physician to take a history from the claimant. And the histories that I get from claimants in cross-examination are far more detailed and usually far more favorable to what we're arguing than what a physician knows to ask, because they're simply not trained. They're not trained to take a history with respect to litigation. They're going to talk. That's why they rely, I think, they default an awful lot on temporal causation.
Right.
So we were concerned about the results, so that we elected not to get an IME because we didn't feel that we were taking more risks getting one than we weren't, because we knew immediately that notice was going to be a huge defense in this case. And the case law really shows that if you fail to give notice, but the employer produces an IME that gives causation, the panel is going to find some way to establish the case against you. So we felt that strategically we were better off going in without one and attacking the treating doctor. And ultimately we got some pretty good testimony from him.
And did you discuss the possibility of, I know you talked about crafting your cover letter, but you have to have a fair degree of confidence, I think, in an IME doctor that they will give you language that makes causal relationships specific to a history as being provided by a claimant being accurate in order for their causal relationship opinion to survive.
Right, and not all physicians oftentimes do that. If what
Right.
the claimant says is accurate and true. And I think the other problem here too is this is such a unique circumstance that a physician doesn't necessarily, like we would, or an employer would, or an adjuster would, immediately smell something fishy on a 7-month late report of an accident. The doctor is going to look purely at the medical records. He just doesn't really care what the C3 says. And he may ultimately decide that he believes the claimant for some medical reason because he believes he can link A to B to C to D. So we felt, well, we're going to attack, we'll attack the doctor on causation to see if he equivocates or agrees that it's speculative, because we had so many potential causes in the history. But we were going to really hang our hat on notice and say, listen, let's just assume arguendo, an accident occurred. We don't contest it. He tore his rotator cuff at work. He never told us. He never told us. And in fact, in the common sense, not legal definition, he's actually just told us for the first time in testimony today. He's never bothered to do anything other than call a lawyer, and his mom may have done that. So,
Should we break for a commercial and do a time check?
And do a time check?
This presentation has been brought to you by the law offices of Melissa A. Day. That's good coffee.
So, yeah, the strategy here was narrow, and it was thoroughly discussed with the client because we really wanted to make sure that everyone agreed how we were going to handle this case. And thankfully, we had a seasoned, excellent adjuster who agreed and honed in on the same issues himself. There's no notice here. This case smells to high heaven, and we've got to do something about this. We take the testimony.
So you won, right?
Not yet. Close. We take the case to a reserved decision, and our arguments focus almost entirely around the fact that the doctor's testimony was equivocal, and even if you accept the doctor's testimony, what you're left with is an untimely reported accident with all kinds of prejudice. You couldn't swing a dead cat without hitting prejudice in this case. We were up to our eyeballs in prejudice, and the claimant didn't take any steps to ameliorate that in testimony or their arguments. So at the end of the day, the judge does what a lot of judges do. He took a step back and went back to sort of, Comp 101. Well, this entire system is tilted in favor of the claimant. I have enough evidence, I think, that he hurt his shoulder at work. I'm going to establish this claim. So what the judge says is, well, Section 21 applies. The presumptions apply. I'm going to buy the testimony from the doctor that this is related to work. But I'm also going to establish the case, and without explaining why, I'm going to establish the case as an occupational disease. And I'm going to find the date of disablement is the date that he first was told and sought treatment with Dr. Rao in December of 2014, meaning that his report in January was timely. Because he did file the C3 within 30 days of his meeting with Dr. We won't say his name for the sake of anonymity.
Well, I'm sure when you read that decision, you were calm and logical in your response, weren't you?
Much like the judge who issued it, I was loud. I was a little bit irritated. Probably if he and I sat down, we'd agree that we're more alike than we are disalike, actually. But I was not a happy camper. I said words that I can't repeat here. I may have thrown objects. But nevertheless, we were angry, and we wanted to make them pay for it. So we decided that we were going to file an appeal. And you think, okay, great, I got a de novo review. Maybe the panel decides that this common sense argument makes common sense.
So you're talking about you filed an application for a review?
Yeah, to a 3-member panel of the board.
And when you say de novo review, can you explain that?
Yeah, de novo review means that it's the circumstance where an appellate board or court gets to review everything and decide all of the issues from scratch. Ordinary appellate review is generally limited to abuse of discretion or substantial evidence, which is what we ultimately have with the third department. An appellate court will not look to the underlying facts and make new determinations about the weight or credibility of evidence. They will simply say, I've looked at the evidence and I find that there's no reason to disturb the findings because they're supported by some evidence. even though a contrary conclusion might be reached,
another trier of fact might reach a different conclusion.
Yeah, we're not inclined, and that's a typical appellate review standard. But in this case, we have entirely a de novo review. So they're going to go back and they're going to root around every document in this record, which this is a very small record, by the way, very much in line with our plan of litigation. Our plan of appeals in this case was to keep it really narrow and keep it really simple. And
which is a good strategy for both the board and the third department.
Yes, and I'll get to that because I think I've been to the third department enough now and seen the judges that I have some intelligent comments to make on it, and that they all align with what you had told me from the beginning, which I may or may not have fully embraced initially, because I had some.
You always come along kicking and screaming eventually.
Yes, I'm a slow learner, as my wife will attest. So we filed an appeal to the full board, and they played the same sleight of hand. They did me a favor this time, though, and actually acknowledged my argument. They said, well, we understand that the employer is arguing that this is really an accident and that it should be time barred. And in their analysis, that's when they recite the findings. And in their analysis, they make no reference to it. They just simply say...
They acknowledge it, and that's sufficient.
They acknowledge it, that's sufficient. Yep, we acknowledge your argument, and by the fact that we refuse to address it, even ordinary appellate courts will say, we have considered the remaining contentions and find them meritless. At least you telling me that you read what I wrote and you don't agree with it. The panel just says, I've read what you wrote, and then nothing. Full stop. And then they give you their analysis, and their analysis was boilerplate affirmance. We find enough evidence in the record to support the judge's ruling, and we not only agree that it was proper to establish the claim, we agree, and we, as an OD, we agree that it was appropriate to authorize the surgery and the case of no further action. And of course, you get your $150 penalty for losing an appeal to the board, which is like the only place where you get an automatic penalty for not prevailing. I wonder if we get that back. In any event, so then was the hard sell, and this has to do with strategy, and that brings us to our last slide. Honoring the law. We talked about what Section 18 tells us, which is that...
when you say we, you're talking about now the conversation with our client.
Absolutely. We, and then we here. We, you and the television audience as well. We all know now that you have to give your written notice to your employer within 30 days. There are certain ways under which it can be accepted and be waived, essentially. We also need to discuss the fact that Section 23 of the Workers' Compensation Law, the section that authorizes appeals to the board panels and the full board, indicates that once you have received an adverse board panel decision, there is no further stay. There's some case law that talks about whether ATF stays may be in place for full board or other things, but there's no stay of any award. So once we lost with the board panel, the client has to pay this case as though it's fully established and has to treat the case as though it's fully established and has continued to do so to this day, with the extent that, throughout the course of the litigation subsequent to that on different issues, mitigation efforts were undertaken, of course. And
That's smart.
And you cannot leave a case go. If you leave the case go, it's going to turn into one of those monstrous or sometimes zombie cases where they just keep popping up and you can't kill it. So we filed to the third department after long discussions with the employer about the costs, the implications, the fact that we were going to have to pay for this whole case while we proceeded to the third department, and the relative merits of the appeal. And the primary argument that goes on and the primary discussions that's had among us too, we discuss it ourselves, we roundtable these cases because it's such an important decision, is whether you're going up on a question of law or whether you're going up on a question of substantial evidence. Because the appellate division is one of those courts of limited review. They are not generally going to second guess the findings of fact of the board. The board merely has to have some evidence to support, in some cases a rational basis, but some cases substantial evidence to support whatever factual findings they make. The third department generally will not entertain an appeal, or you have no chance of a reversal if you're just simply saying, I think that the board is misreading these facts, or I think that the substantial evidence actually, if we put this on the scales of justice, they're going to say, well, our scales of justice don't matter, it's the ones below. So we went to the technical difficulties.
We're doing a time check.
We're doing a time check. I do have a watch right here. So we go to the third department with the employer's blessing and basically told us to come back with our shields are upon it. And I promised them I would do so. And we filed a brief to the third department. And briefs to the third department compose a bunch of different elements. You may have seen them, you may not have. The two primary elements are a record on appeal. I know it's kind of washed out in white. Here, I'll put it right in the middle here. Kind of washed out in white. It ends up being a bound booklet. This one is approximately 326 pages long, and it contains all of the evidence that the parties agree is absolutely necessary for the court to review. They don't want to look at e-case. Heck, none of us want to look at e-case sometimes, and half the time it doesn't work. Well, that's actually pretty good now. They've worked on it a lot. But they get a record on appeal, and then you produce a brief, which contains a handful of elements to it, a basic statement of the nature of the case, facts of the case, which gives references to pages in the record on appeal, and of course your arguments. And when you're drafting an appellate division brief, this is my experience, it is a group effort. You may be typing it yourself, but there's a lot of time spent in consultation with, for example, Melissa, who has a ton of third department experience from retirement special funds and working here. My colleagues about whether my arguments are horrible. Some of them would just like to tell me they were horrible anyway, just for fun. We had a lot of discussion, and you do have a lot of discussion because it takes many hands, I think, to get one of these things to work. But one of the statements I was going to make about the learning process was, one of the earliest things I had been told when I handled my first one of these was, you have to treat the third department like it's a comp lesson from A to B. You have to give it to them in the most distilled, simple fashion. Otherwise, you will confuse the clerks, you'll confuse the court, because you are a mile deep in an area of law that can be 10 miles deep. And they are looking at 6 inches deep and a mile wide because the third department handles every administrative appeal.
Correct.
So this brief was tailored for that purpose. And it's basically a lesson in workers' compensation. There are 3 kinds of claims you can have. That's literally how it starts out. You can have an accident, and it discusses what the case law says is an accident. And honoring the law, we'll get into that briefly. It's common sense. If common sense tells you it's an accident, it's an accident.
That's probably why the board got it wrong.
You said that. There is a repetitive stress injury or a repetitive motion injury. It's not an occupational disease because ODs are a little different. We'll tell you what an OD is first, because then we can create it's a hybrid, really. Repetitive stress is a hybrid. An OD is usually a disease process that takes a long period of time to develop and is caused by a distinctive feature of employment.
Is repetitive sitting on a hard bench considered a distinctive feature of our employment?
You're fired. So,
can I go?
No. So, an occupational disease, you can't just common sense is an accident, but an OD, you have to isolate a distinctive feature of the employment that brought about the disease process. And the rationale for the extended timeline for notice of an OD is because the extended period of time in which it generally takes an employee to recognize either that they have a condition or to have a physician recognize they have a condition related to employment. The case law from the 50s, which is sometimes some of the best and most obviously written case law, explains that that's why you get a longer time to give notice on an OD than you do on an accident, because it might take you a while to figure it out. The middle of the road is the hybrid, repetitive stress. It's not long enough in time to prove that it's a disease in sort of the common parlance of the word, but it's short enough in time so that you get a discrete period, and it might not necessarily be a distinctive feature of employment in general, but a distinctive feature of the employment during that period of time.
Wouldn't you agree that sometimes the board uses the repetitive stress theory too to circumvent the requirement that the condition arise out of a distinctive feature of the employment?
Absolutely, especially if you have a short enough period of time between the claimant first reporting symptoms and the claimant seeking treatment. So that means if a claimant doesn't come in and say, yes, it's been going on for years, but says I started to have this problem and about a month and a half or 2 months later, I sought some treatment, and the board will say, yeah, we're going to treat it as a happening of an accident, but we're going to give you a date of disablement or date of accident that's more appropriate with, let's say, when you first sought treatment. They do get away from that. And if the repetitive stress is used to get both ways, essentially it's sort of an out, depending on what you want to do if you have the right facts. Like, you can go either way. So we spoon-fed to the board what these three things were. These were the three kind of claims you can have. There's not really a fourth.
So it was accident,
repetitive stress, and occupational disease.
And
we went through each one, and we said how it is obviously an accident. It's obviously an accident because the claimant said so. The claimant's doctors took histories to that effect. The claimant's doctor failed to provide a history of a disease. He didn't say disease, so we can't jump into OD right away. And that the claimant's work activities were over a very discrete period of time. He had a specific onset. And then the next part of the argument was, okay, here's what a repetitive stress injury is. Even if you don't buy it's an accident, it is obviously the only other obvious choice is a repetitive stress injury.
Which would lead to it being established as an accident.
On the first date that it occurred, right? So he had an onset of symptoms. He may have been working through the pain, if you believe what he says is true, which is contrary to the medical. And he continued to have that thing going, that process go along from the 2 months that he was potentially lifting a wheelbarrow.
So for 2 out of 3 of those theories, you win.
Yeah. The third theory, occupational disease. Well, we have a rotator cuff tear, which the doctor says is rare.
In a 20-year-old.
In a 20-year-old. And he says, well, and I have to be equivocal about.
I don't think Dr. Grant has ever met a shoulder that didn't have a rotator cuff tear. Do you?
No, I was actually thinking that he might do rotator cuff repair on a banana if you gave it to him. So at the end of that banana would have a serious rotator cuff when it was done and a 50% schedule loss of use.
At least.
At least. So the doctor says, well, it's a rotator cuff tear. He testifies it's probably from a traumatic injury, but he can't be entirely sure. He's also equivocal about causation in the first place. And we point that out to the third department and say, well, on top of all of this, if I'm arguing accident versus OD, I really probably still have a CR argument in the first place, and you guys should really consider that, but that's not what I'm asking for here. I'm still asking for you to just exercise a little common sense and find that this is an accident so that we can all go away. And
that was one of the most striking things about your strategy in this case, from my perspective in reviewing how this case was handled and what you did in developing your strategy with the client, was that you did have a causal relationship defense, and I think you took it piecemeal, and you really focused on the idea of this being an accident first because you had the strong notice defense.
Right.
And the causal relationship defense for both, either whether it was an accident or an occupational disease, you kind of held that in reserve.
Right.
As your backup. You said, I have these 2 defenses. This one is much more attractive. Why don't you seize on this one?
Right. And of course, the causal relationship argument is not one that you have a good chance of winning on at the third department because you're talking about weight of evidence. And we only had one doctor because, again, we went with the choice not to get an IME for the risk. We were risk averse about what the IME might tell us about the case, and we didn't want that to kill the notice argument. Because I could perceive even the third department saying, well, there's unanimous medical evidence here, the board's decision below won't be disturbed. And as we'll talk about when we get to the final conclusion, there was a touch of that anyway in our case. So we laid out all of our facts. The brief to the third department may have been a bit snippy. I may have used the word fiat at one point. I may have suggested on several occasions that the decision below was contrary to common sense. In fact, I think I tried to say that as many times as possible.
What I think you really called the board out on was that they were trying to circumvent the limitations that would be imposed on the compensability of the claim if this was established as an accident.
Exactly, and that was the very last paragraph of the brief simply says that there is no explanation in the decision below for why the case was deemed an occupational disease and not an accident. But here, I'll give you one, and here's why. Because the claimant articulated a theory of OD essentially conceding that the case was untimely brought or was untimely noticed to the employer, and therefore the board made this claim compensable where it otherwise wouldn't. And notice is a disfavored defense because it oftentimes leaves the claimant without the ability to obtain coverage through other means, as they would on a disallowance on any other issue. So at the end of the day, we waited around, we defended the file, we continued to defend the file through other subsequent claims that were related to the case. And on February 2nd? I think it was February 2nd.
Pretty recently.
Yeah, February 2nd, the third department issued a ruling. It's public record. I'm still not going to say the names, but if you want to know the case, we can provide it to you. You email us, we'll send it to you. Found that, contrary to the findings below, the board's decision simply did not contain sufficient or substantial evidence to find that there was an occupational disease at play. Now, they could have stopped there and rescinded the decision and simply said, we don't find substantial evidence because the board failed to articulate rationale. And in fact, that was one of my arguments. The decision below failed to articulate any rationale. So I argued that the third department couldn't really conduct an intelligent review because the board didn't tell us what facts they relied on. The third department actually went farther and said, no, we've read the record and we actually entirely disagree with you. We are reversing. And we are going to.
And they reversed on a substantial evidence standard. They said that there was a lack of substantial evidence.
Right, and I had argued all along. It was actually a little bit shocking to me. I'd argued all along that this should be a legal reversal.
Well, I mean, lack of substantial evidence really is a reversal as a matter of law.
Right. It's just, the standard. I was actually kind of hoping for them to say, yeah, this doesn't meet the standards of common sense, and we're sending it back. But they found insufficient evidence. There was no substantial evidence. They actually found substantial evidence. They went further, though, and found substantial evidence to support a finding of accident. And they pointed to the lack of a distinctive feature of employment. They pointed to the fact that the doctor's testimony was equivocal. And interestingly enough, when I was reviewing the record here, they found no evidence from the physician that the claimant's condition was related to a distinctive feature of employment. And it got me wondering, I had made that argument in the appeal, but I wasn't entirely sure that I was going to get any traction with it. And it turns out that when we took the testimony of Dr. Rao, let me find it here. Did I not mark it? Okay. I asked the doctor, am I right in saying that your opinion that the most likely cause of the claim of this event or this injury was a single traumatic event as opposed to a repetitive type activity? So I'm trying to suss out the doctor. Like, if you think it's an OD, come out and say it, dude. We need to know. Because otherwise this record's going to be a mess. Again, no. So it's a non-responsive answer. But whatever. We'll let him expound on it. I think I did answer this question already. I did hammer this guy a lot. I remember taking this deposition. That it is possible that his volleyball in
James,
part...
you're wonderful.
That his volleyball in part with the repetitive overhead injuries from hitting and spiking could lead in part to this rotator cuff finding that we're seeing. So it's very possible that it could be related to repetitive injuries, but as well it could be related to a single traumatic event. So the one place where he actually says repetitive injuries or a distinctive is offered an opportunity to give a distinctive feature, he talks about volleyball, not the claimant's employment.
Don't you think that really, at the end of the day, that it's likely that the claimant's participation in sports is what led to this injury?
Oh, absolutely. I absolutely think so. I have other theories about it as well, but they were contained as sort of side notes in medical records and things that our physicians would simply be unable to comment on. We sort of become lay doctors when you do comp long enough. You start to develop the little, you learn the tricks and you figure out, okay, well, that doesn't make sense. That doesn't make sense. You spend a lot of time trying to research things. You develop theories and then you send them to doctors hoping that you were right. And sometimes you're validated and then you know to use that one again. And sometimes you're told, yeah, you're barking up the wrong tree. So I'm not entirely sure, but I do think that, yeah, there definitely was an element of this. And is it entirely possible that he tore his rotator cuff playing with his friends and he just simply doesn't want to tell his mom that he got a little rough on the basketball court? I think that's entirely possible too. So looking at the clock, we've almost run it out. We're going to do Q&A, right?
We certainly can.
Yeah, let's do a little Q&A. We're going to ask our associate producer here. He's literally an associate and a producer, so that works.
Those are coincidental.
That's coincidental.
Yeah.
To open it up for questions. Am I hearing somebody's hold music?
Does anybody have any questions?
I'm still hearing the one.
They were the last one on the list. That's one.
Does anybody have any questions?
I think Rob just muted everybody.
Oh.
No.
Just the one. I'm making noise.
Ah.
Oh, there they are, yeah.
Well.
I don't hear any questions. Rob, do you hear any?
Nope.
No?
So I muted everything.
Is Mark J on the line?
Yeah.
Hi, Mark. I hear him.
Yeah. So I think Mark was just telling us too. This an interesting factual point in the case was we were ultimately able to produce some evidence that that specific day and time that the claimant gave, he wasn't working on the asphalt crew. He was working on the brush crew. So I did ask him if he could be mistaken because I tried in a gotcha moment, a Perry Mason moment, which we do get them sometimes.
How do you know even who Perry Mason is?
This is a PG show, so I'm not going to reply to that. But sometimes you get a Perry Mason moment. So I pointed out that on the day that you claim to have been lifting asphalt, you were actually doing brush work. And his answer was, well, I might have been wrong. I mean, all these forms were asking me for dates, and I was trying to be specific because I was trying to follow the instructions. His mom was filling out the form, so I don't know if I buy that entirely. But it is true, Mark, and this brings us, since we're on the last line, honoring the law, a claimant need not really give the specific date of the accident. And it's really common for a claimant to say, well, it was either Monday or Tuesday, I can't remember. A lot of these people do have somewhat monotonous jobs, and Monday may run into Tuesday or something if it's a particularly minor injury. Generally not, though. You remember what I remember when I threw my back out the first year I started working for you when I was building a wall in front of my house. Oh my God.
It was at home.
It was at home.
Oh, that's right. I remember that now.
I remember when it happened because I took a picture of the wall. And
do you remember the specific day?
No, but I'll find it. I could figure it out. And that was like 5 years ago almost. I remember because I was seriously.
Credits are rolling. I love it.
Oh, associate producers are horrible. He's rolling the credits. If there are no further questions at this point, I want to thank you all for bearing with us. We wanted to do something new and more technologically advanced because
Hope it was entertaining.
Yeah, a lot of people were doing the webinars, and it's just, like we just can't. We have to be a step ahead of everyone else.
Yeah, we didn't. I mean, imitation is the sincerest form of flattery, but so hopefully people will be doing TV shows for you in a couple of years, and we'll have moved on to the next thing.
Yeah.
Holograms.
I will be giving one of these presentations from the Bridge of the Enterprise if I have my way at some point. So, in any event, thank you very much. We really appreciate it.
Please stay tuned into next month's excellent teaching tool on how to not handle an apportionment claim. So, thanks again for tuning in.
Yep.
Until next month, we're signing off.
Yep.
Nice job.